The Trustee's Guide to Commingled Assets. Commingling assets is a common issue we see in our trustee clients, and it's one that can land you in some serious hot water. While it takes a little extra work and bookkeeping to keep trust funds separate from your personal funds, it's your absolute duty to do so. What are commingled assets? The term commingled assets refers to when a trustee mixes trust money or other trust assets with their own funds or other non-trust asset. For example, if a trustee were to deposit trust funds into their personal bank account, those funds would be commingled. Is a trustee allowed to commingle assets? No, a trustee cannot commingle trust assets. Under the California Probate Code, trustees have a duty to keep trust property separate from other property. This means that any commingling of funds or other trust assets is strictly forbidden and is considered a breach of the trustee's fiduciary duty. It also means that the trust bank accounts must be titled in the name of the trustee on behalf of the trust and not in the name of the trustee individually. Any violation of this requirement can also be considered a breach of fiduciary duty. What should I do if I accidentally commingle assets? As trustee, if you accidentally commingle assets, you should simply fix the problem immediately and document the steps you took to fix it. For example, suppose you accidentally deposit trust money into your personal account. In that case, you should move the money to the trust account as soon as you realize your mistake and document exactly what happened in the trust records. You should also prepare for the beneficiaries to request your bank records to demonstrate that the funds are no longer commingled. It's also a good idea to consult with an experienced trust litigation attorney if you breached your fiduciary duty as trustee by commingling assets, even if you do so accidentally, just to make sure you can limit or manage any exposure you might have. What will happen if I commingle assets? Under the California Probate Code, when a trustee violates any of the duties that they owe to the trust beneficiaries, including the duty to keep trust property separate, it could be considered a breach of trust. This means that if you commingle assets as trustee, you might have committed a breach of trust. If a trustee commits a breach of trust, under the California Probate Code, the beneficiaries or co-trustees of the trust can ask a court to do any of the following things. 1, compel the trustee to perform their duties. 2, to prohibit the trustee from committing a breach of trust. 3, to compel the trustee to address a breach of trust by paying monies or otherwise remedying that breach. 4, to appoint a receiver or a temporary trustee to take possession of the trust property and properly administer the trust. 5, to remove the trustee. 6, to set aside acts that the trustee undertook that were in violation of their duty. 7, to reduce or eliminate compensation for the trustee. 8, to impose an equitable lien or a constructive trust on property owned by the trust. 9, to trace trust property that's been wrongfully disposed of and recover the property or its proceeds. Depending on the circumstances and the severity of the situation, a breach of trust by commingling assets could also be a cause for a civil lawsuit against the trustee. Can I be removed as trustee for commingling assets? Yes, commingling assets can be the grounds for your removal. Under the California Probate Code, a trustee may be removed in accordance with the term of the trust by the court on its own motion or on the petition of a settlor, co-trustee, or beneficiary. A breach of trust, such as commingling trust assets, is one of the grounds for removal. When should I contact a trust litigation attorney? If you've been accused of a breach of trust, like commingling assets, you should contact a trust litigation attorney immediately. Even unintentional commingling of trust assets can create serious problems for any trustee, and you'll need an experienced trust litigation lawyer to help you navigate the situation and avoid or at least manage any potential exposure. Have questions? At RMO, we protect people like you every day. Give us a call, shoot us an email. The consultation's always free. Thanks for watching.